Hello friends, welcome to this lecture on preliminary concepts of the Companies Act 2013 for Intermediate IPC course, Paper 2. I am CA Parag Sodhani from Jaipur, your mentor for this lesson. Students are requested to please note the disclaimer statement for this lecture. Besides this lecture, students are also advised to refer to the study material, including supplementary study materials, if any, and other relevant legislation for latest provisions or amendments required for forthcoming exams. So friends, before we start, let me introduce you the topics which we are going to cover. First topic is the introduction of companies. Next topic will be features of company. Next topic, corporate veil, its lifting. Next, kinds of companies. Next topic, conversion of companies. Then, when companies must be registered. Thereafter, promotion or incorporation of company. Next topic will be preliminary contracts. Memorandum of Association, Articles of Association, the Doctrines, and finally, Service of Documents. So let's introduce ourselves first of all with the law relating to the companies. The law relating to the companies are covered under the Companies Act 2013, which is a very comprehensive law covering all the procedures and all the requirements to be followed by a company. At this very moment, question arises as to what a company is. But one thing that we already know is that joint stock company is one of the forms of businesses. To understand it in much detail, we'll revert back to what we already know, that is a partnership firm. Let's take an example. Suppose there are three persons, W, G, and O, who jointly make an agreement to enter into a partnership to be known as WGO and Associates. On the other hand, the same three persons, W, G, and O, make a company to be known as WGO Private Limited. The question in front of us is that what is the difference between WGO and Associates and WGO Private Limited? The answer to this question is WGO and Associates is none other than the collection of the three partners. But same is not the case with WGO Private Limited. WGO Private Limited is actually a person which has separate existence. We can conclude that partnership firm has no separate existence, whereas a company is an artificial person with separate existence. Now, after briefly knowing about the company, we shall introduce ourselves with the Companies Act. Earlier there was the Companies Act 1956, which has now been replaced by the Companies Act 2013. In the earlier company law, there were 658 sections in all, which were classified into 13 chapters. But in the new Companies Act, that is the Companies Act 2013, there are 470 sections in all, classified into 29 chapters. Further, the earlier law had 14 schedules, which are now reduced to just 7 schedules in the new Act. However, let us know that out of the 470 sections, only 282 sections have been notified so far by the central government. Question arises, what about the rest of the sections? So, the rest of the sections are going to be studied from the Companies Act 1956. As far as the syllabus of CA IPC intermediate course is concerned, we have in our course Section 1 to Section 122 of the new Act. To enter into further details of company, let's now know about the features of a company. Number 1. Company is an artificial person. Number 2. Company's existence is separate from its members, directors, etc. Number 3. Company has a perpetual succession. The concept of perpetual succession can be understood in the following manner. Let's suppose WGO Private Limited is a company with W, G and O 3 members. Even if W, G and O leave the company, the existence of WGO Private Limited is not going to be affected. This is known as perpetual succession. After a company is being formed by its promoters, it requires two major things. Number 1, money, and number 2, management. Whereas money is contributed to the companies by its shareholders, who are also known as its members, the board of directors are responsible for the management of the company. Since shareholders contribute the money, they are known as owners of the company, and the board of directors are known as the agents of the shareholders. Being the owners, the shareholders take decisions about company in general meetings. This is done by passing various resolutions. Resolutions are of two types. First is the ordinary resolution, in case of which the consent of more than 50% shareholders is required. The another one is special resolution, in case of which the consent of at least 75% shareholders is required. Board of directors also take decisions about routine matters of the company. They do so by passing board resolution. For passing board resolution, the consent of more than 50% directors is required. Every company has two major documents which decide the future of the company, its powers, and the way it will function. The two documents are, first, the Memorandum of Association, which is in short called MOA. This document states the powers, functions, roles, responsibilities of the company. On the other hand, the second document is the Articles of Association, which in short is called Articles of Association or AOA. This document states the internal rules and regulations which are applicable to the members, directors, managers, etc. We'll discuss about these two documents in detail later on. After having been known about the introduction of company, let's now move on to the next most important topic, that is the concept of corporate veil. In the renowned case Salomon versus Salomon and Company Limited, the court gave two very important judgments. Number 1, every company has its own existence, and another one is that the shareholders cannot be held liable for the company's acts, even if virtually the entire share capital is held by a single person. We can say that if W, G and O are the 3 members of a company, then they are covered by a veil of WGO Private Limited. This veil is called corporate veil or the veil of corporate personality. General rule says that a corporate veil can never be lifted. Now this takes us to a very important question as to what is meant by lifting of corporate veil. Lifting of corporate veil means to disregard the corporate entity and instead to pay regard to the realities behind the legal personality. In other words, it means to hold the members or directors personally liable for the acts of the company. Now we'll come across some such cases in which corporate veil is lifted. To determine whether a company is enemy company or not, it is not the status of company which is considered, rather it is the status of the members which is considered. This was decided in the case Daimler Company Limited versus Continental Tire and Rubber Company Limited. Lifting is also done where the corporate entity is used to evade the taxes. This was decided in a well-known case, Sir Dinshaw Manning Patent. Another such situation is when corporate entity is used to avoid legal obligations such as bonus by diverting its funds to a fake corporate entity. The relevant case was the workmen employed in Associated Rubber Industries Limited, Bhavnagar versus Associated Rubber Industries Limited, Bhavnagar and another. Fourth case is when a company forms other company to act as its agent. The relevant case is Smith, Stone and Knight Limited versus Lord Mayor, etc. of Birmingham. Lifting is also done when corporate personality is used for illegal or improper purposes. Let's now come to a very important topic, that is the kinds of companies. The first classification that we are going to study is limited company and unlimited company. Limited companies are those the liability of whose members are limited. That is, their liability is limited to certain extent. These limited companies can further be of two types. One, the company is limited by shares. In case of this kind of company, the liability of its members is limited up to the unpaid amount of shares. For example, say if X is a shareholder holding 1000 shares of face value ₹100 each, out of which ₹80 has been paid up, then the unpaid amount ₹20 into 1000 shares, that is in all ₹20,000, shall be the liability of member. Second category of this limited company is the companies limited by guarantee. Liability of members in case of this company is limited to the extent of guarantee given by member at the time of acquiring membership. If a particular shareholder has guaranteed to pay a sum of ₹2 lakh, then the liability of that member shall not exceed ₹2 lakh. The company limited by guarantee can once again be classified into two types. First is those companies which are limited by guarantee and having share capital, and another is that kind of company which is limited by guarantee but does not have any share capital. Now it is to be noted that the companies limited by guarantee with share capital will be a combination of the two. Firstly, their members will be liable up to the amount of unpaid share capital, and secondly to the extent of guaranteed amount. Next comes unlimited company. As the name suggests, the liability under this kind of company is unlimited. In other words, the members of such company may be personally held liable. Further, the unlimited companies can also be with share capital or without share capital. On the basis of size of a company can either be a one-person company, that is OPC, it may be a private company, or it may be a public company. Section 2 defines all three of these companies. OPC is defined by clause 62, private company is defined by clause 68, and public company is defined by clause 71. On the basis of number of members, we can differentiate between these three companies as follows. In case of one-person company, there is only one member. In case of a private company, there are minimum of 2 members and maximum of 200 members. In case of public company, minimum limit is of 7 members without any maximum limit. Number of directors minimum of one director is required in case of OPC, 2 in case of private company, and 3 in case of public company. But the maximum limit is same in case of all these 3, that is 15. Minimum paid up capital in all these companies will be as prescribed by the central government. Finally, the name of OPC must be followed by the words one person company, which has to be written in brackets below the name. The name of private company must be followed by the 2 words private limited, and the name of public company must be followed by the word limited. Now friends, let's enter into the details of a private company. Private company is that in whose articles there are 3 restrictive clauses. Number 1, there must be restriction on the right to transfer its shares. Number 2, its articles must put limitation on the number of its members to 200. Now while calculating the counting to 200, we have to consider 3 very important points. Point number 1, those members who are employees of the company need not be considered. Those members who were employees earlier need also not be considered. And the joint shareholders have to be counted as 1. The third restrictive clause is that the articles must put prohibition on invitation to the public to subscribe its shares or debentures. Friends, before entering into the depth of a public company, let's first know a small concept of a small company. Small company is actually a private company having paid up capital not exceeding rupees 50 lakh or whose turnover does not exceed rupees 2 crores. But remember friends, small company can never include number 1, a holding company or a subsidiary company. Number 2, a section 8 company, which we are going to discuss few topics later. Number 3, small company can never be a body corporate which is formed under a special act. Next is a public company. A public company can be formed in 2 modes. Number 1, every company which is not a private company and which has a minimum capital as prescribed by the central government will be a public company. In other mode, a company which is a subsidiary of a public company will also be considered as a public company, even if it is a private company under its articles. Now let's move on to the next classification, a holding company and a subsidiary company. To understand this concept, we again take an example. Let's say there are 2 companies, H and S. As per Companies Act, H will be considered as a holding company of S if S is its subsidiary company. Question arises, when will S be considered to be the subsidiary of H? This will happen in the following 3 cases. Case number 1, if H controls the composition of the board of directors of S. H is considered to control the composition of BOD of S if it has power to appoint or remove majority of its directors. Another way of becoming a subsidiary is if H controls more than half of the total share capital of S together with its subsidiaries, then also S will be the subsidiary. For example, H has 35% of shares of S and M, which is a subsidiary of H, also has 20% of shares of S. In this case, together H holds 35 plus 20, that is 55% of shares of S, which is more than half. Third case is, if S is a subsidiary of H's subsidiary, then also S is a subsidiary of H. For example, if H holds 55% of shares of M, then M becomes its subsidiary. In the similar manner, if M also holds 60% of shares of S, then S is the subsidiary of M. In this situation, naturally, S is subsidiary of H also. Section 19 of the Companies Act highlights a very important provision that a subsidiary company can never become a member of its holding company. However, Section 19 also offers certain exceptional cases in which a subsidiary company can hold shares in the holding company. This can happen if the shares are held as a legal representative, or the shares are held as a trustee, or if the subsidiary already held shares before becoming a subsidiary. But remember, in the third situation, the subsidiary company will not have any right to vote. Section 2, Clause 6 defines an associate company. A company A Limited is said to be an associate of X Limited if X Limited has significant influence in A Limited. Significant influence means having control over at least 20% of total share capital. Here, total share capital includes equity share capital and convertible preference share capital. However, shares held in fiduciary capacity need not be counted. Significant influence also means to have control over business decisions of A Limited. Next is the concept of a government company. Let's understand it with the help of an example. Let's say this is the paid up capital of X Limited. Out of this total paid up share capital, at least 50% of the capital is held by central government or the state government or both governments taken together. If this happens, X Limited becomes a government company. Another way of becoming a government company is every company which is a subsidiary of a government company is also a government company. Next kind of company is a foreign company. X Limited is considered to be a foreign company if it satisfies three conditions. Number 1, it is incorporated outside India. Number 2, it has a place of business in India. Such place of business may be run by such company either by itself or through its agents. Further, it may be run physically or electronically. Condition number 3 is that X Limited must conduct any business activity in India. Friends, now comes a very important category, that is the companies with charitable objects under Section 8. Let us say there is a company Z Private Limited or there is a company Z Limited. This company will be called as a company with charitable objects under Section 8 if it satisfies three conditions. Condition number 1, its object must be to promote commerce, art, science, sports, education, etc. Second condition is that it must apply its profits in promotion of its objects only. And third condition is that it must have prohibition on payment of dividend to its members. If all these three conditions are satisfied, then the central government would grant license under Section 8 to Z Private Limited or to Z Limited. A very important effect of the granting of license is that now Z Private Limited need not have the words Private Limited in its name, and Z Limited need not have the words Limited after its name. Once the license has been granted, the company would be registered by ROC to become a Section 8 company. Can the license of Section 8 company be revoked? Answer is yes. In the following three cases, the license of Section 8 company can be revoked. Number 1. If any of the provisions of this section have been contravened, that is, if the aforesaid conditions are violated. Case number 2 is if the conditions under which the license have been granted have been contravened, then also the license can be revoked. And the third situation is if the affairs of the company are being conducted in a fraudulent or prejudicial manner, then also the license can be revoked. Once the license has been revoked, its effect will be that now the name must be followed by the words Private Limited or by the word Limited. If revocation has been done, then central government may also direct for either amalgamation of that company with another Section 8 company having similar objects, or it may order for winding up of that company. Now let's move on to the next classification, that is the dormant company. Any of the following two cases would cover a company under the term dormant company. Firstly, a company which is formed for a future project or to hold assets or intellectual property, and which does not have any significant accounting transactions. The question arises, what are the significant accounting transactions? So the Companies Act states that any transaction other than these four will be called significant accounting transactions. These four are payment of fees to ROC, secondly, payment made under this Act or other law, thirdly, allotment of shares, and fourthly, payments for maintaining office and records. If a company does not have any other accounting transaction than these four, then it would be considered as a dormant company. Second way to become a dormant company is every inactive company is also considered as a dormant company. Nidhi company. It is a company which receives deposits from its members and lend money to its members with the sole object of developing cost-cutting and saving habits among its members. Next is public financial institutions. As per the Companies Act, 5 institutions will be categorized under this kind. First is LIC of India, that is the Life Insurance Corporation. Second is Infrastructure Development Finance Company Limited. Third is Unit Trust of India. Fourth is any institutions which were notified by central government under Section 40A, subsection 2 of the previous company law, that is the Companies Act 1956, will also be considered to be the public financial institutions under the new Act. And the last one is any institution which is notified by central government in consultation with RBI. Friends, now coming across various kinds of companies, now we move forward to the next topic, that is how to convert a company from one form to another. To convert a public company into a private company, there is a requirement to pass a special resolution to insert the restrictive clauses in the Articles of Association of the company. Second requirement is to take the approval of the tribunal, that is the National Company Law Tribunal. After this, the altered articles, together with the tribunal's approval, shall be filed with the ROC for registration within 15 days. This will complete the formalities of conversion. As far as conversion of private company into public company is concerned, the Companies Act says that if a special resolution has been passed to remove any of the three restrictive clauses under Section 268, then the company will no longer be a private company. Once the restrictive clauses have been removed, the altered articles shall be filed with ROC for registration within 15 days. Section 464 of the Act provides when the companies must be registered. As per the section, no association or partnership shall be formed if it has more than 100 members and if its object is to acquire gains, unless it is registered as a company under the company law. If such association or partnership is not registered as a company, then it will be considered as an illegal association. Such an association will have no legal existence. Its members and the associations cannot sue each other, and the personal liability on members will be imposed. However, Section 464 is not applicable in the two cases. Number 1, in case of HUFs carrying on business, and number 2, in case of associations or partnerships which are formed by professionals like a CA firm who are governed by special acts. In these two cases, even if the limit crosses 100 and even if they are not registered as a company, it will not make any violation of Section 464. Next, we are going to understand the term promoters and promotion. What is meant by promoters? In general sense, promoters are those persons who take steps for registration of a company. But friends, Section 2, Clause 69 of the new Act has given a legal definition of this term. As per this section, any person who has been named as a promoter in the prospectus or annual return under Section 92 shall be considered as promoter of the company. Number 2, any person who has control over the affairs of the company, whether as a shareholder or as a manager or in any other capacity, will also be considered as the promoter. Also, any person on whose advice the board of directors of the company is accustomed to act is also to be considered as promoter. But this clause gives a precaution as well. It says any person who merely acts in a professional capacity shall never be considered as a promoter, even if the board of directors is accustomed to act on his advice. After understanding the meaning of this term, let's now check what is the status of a promoter. Remember friends, promoter can neither be considered as an agent nor be considered as a trustee of the company. This is because when the promoter acted, company did not even exist. So, the promoter has a fiduciary relation with the prospective shareholders as well as with the company. Fiduciary relation means the relation of trust and confidence. That is, the prospective shareholders have a very high level of trust on the promoters, and because of this, promoters have a very important duty. The duty of promoter is that he shall not make any secret profits. If he makes any secret profits, then the company may rescind the contract which has been made by him, or the company may compel the promoter to account for the profit. What if a promoter is a vendor of his own property to the company? In such a case also, he shall make proper disclosures of the profits, if any, he has made. If he does not make any disclosures, then the company may either rescind the contract or it may compel him to surrender the profits. A question must be moving in your mind that whether the promoters are eligible to claim any remuneration. Answer to this question is that in the absence of an express contract, promoter cannot demand remuneration for his promotional services, nor he can recover any payments made. Now we are coming across a very important topic, that is the registration or incorporation of a company. Under this topic, we are going to study 3 subtopics. First, the procedure for incorporation of company. Second, the effect of such incorporation or registration. And the third, consequences of incorporation by furnishing false or incorrect information. Starting with the procedure for incorporation. Step 1. Filing of documents or information with the registrar. Let's check what those documents are. First such document is the application in Form INC2 or INC7. Form INC7 is the general application form, whereas the Form INC2 is only for the purpose of registration of OPC. Second document is the Memorandum of Association and the Articles of Association of the company. A declaration shall also be submitted by the professionals as well as by the directors, managers, or the secretary of the company that all the requirements of this act have been duly complied with. Fourth document is the affidavit to be submitted by subscribers to the memorandum, that is those persons who will be the first members of the company. Affidavit has also to be filed by the persons who have been named as first directors in the Articles of Association. Besides these, a correspondence address has also to be submitted so that any communications of the notices can be made. Next document is the particulars of the subscribers to memorandum, that is, their name, their address, their occupation, etc. In the similar manner, the particulars of the first directors named in the articles have also to be submitted, and their interests also have to be submitted. After submission of all these documents, the copies of these documents or information which are filed shall be kept at the registered office until dissolution of the company. Once the documents have been duly filed to the satisfaction of registrar, the registrar shall issue certificate of incorporation, that is the certificate of registration. A corporate identity number shall also be allotted by the ROC. Ministry of Corporate Affairs has recently introduced an integrated process for incorporation, which will help a company to get itself registered within a period of just 24 hours. For this, step 1 that needs to be taken is to file an integrated e-form number INC29. This form serves multiple purposes. It helps to get allotment of DIN for up to 3 directors. Number 2, it helps the company to get reservation of its name. Thirdly, incorporation of company. And fourthly, it helps for appointment of directors of proposed company. After filing e-form 29, a procedure is followed by ROC. If after processing it finds any defect or incompleteness, it gives 15 days time for its removal. But even after refiling the application, any defect or incompleteness is found again, then a second opportunity of 15 days is given. Even after refiling for second time, any again defect or incompleteness is found, then a third opportunity of 15 days is given. After 3 opportunities, if any defect or incompleteness is found once again, then the E-Form 29 is finally rejected by the registrar. After following the whole procedure, finally the certificate of incorporation is granted by the registrar in Form INC 11. Once the company has been incorporated by following the aforesaid procedure, Section 9 says that from the date mentioned in the certificate of incorporation, all the subscribers and members shall be the body corporate in the name mentioned in memorandum. Number 2, company shall have perpetual succession. Number 3, company shall have a common seal. It is to be noted, friends, that now common seal has been made optional for a company. It is not now mandatory. Fourth effect of registration will be that the company will have now power to acquire, hold, and dispose of the properties in its own name. It will also have power to contract in its own name and also the power to sue or be sued in its own name. After having known the procedure for incorporation and the effects of registration, let's now move on to the next subtopic, that is the effect of furnishing of false or incorrect information on incorporation. Section 7 says that if any false or incorrect information has been furnished, or if any material information has been suppressed while incorporating a company, then the person committing such a mistake shall be liable under Section 447 for a criminal offense. Secondly, the promoters, the first directors who have been named, and the persons making declaration like the professionals shall also be liable under Section 447. Besides these 2 punishments, the tribunal, that is the NCLT, may also give an order after giving reasonable opportunity that the management of the company shall be regulated by it, that the liability of the members of company shall be unlimited. The tribunal may also order for removal of company's name from the register, or it may even order for winding up of the company. Suppose a company has been incorporated on this date. In such a case, any contract which has been entered into before such a date are known as preliminary contracts. A question arises that whether a company will be bound by such preliminary contracts after being incorporated. The answer is no. A company is not bound by such contracts after incorporation. Even a company cannot ratify such contracts. In fact, the promoters are personally liable for such contracts. However, there are certain exceptions to this rule. A company can be bound by preliminary contracts in 2 situations. Number 1, when a company adopts the contract by novation, that is, by entering into a fresh contract with such third party. Another case in which a company would be bound by the preliminary contracts is mentioned in the Special Relief Act 1963. It says that where such a preliminary contract is warranted by the terms of incorporation of company, that is, it is mentioned in the objects of the company, and if such a contract is adopted by the company after being incorporated. Further, if the adoption is communicated to the third party, in such a case, company shall be bound by the preliminary contract. Let's discuss a special case for one-person company. We know that one person company has a single member. That's why such a member must nominate a person as his nominee, and the nominee's name must be mentioned in the Memorandum of Association. Question arises, what is the role of such nominee? The nominee shall become the member of company in case of death or incapacity of the original member, that is the subscriber. But remember friends, the nomination can be made only after obtaining a written consent from such person to be nominated. And once nominated, the consent shall be filed by the member with ROC. Company law also mentions certain prerequisites to be a member or nominee of OPC. First such prerequisite is that both shall be a natural person. Second, both shall be Indian citizens. Third, both shall be resident in India. And fourth, both shall not be the minors. There are certain disabilities of an OPC. First of all, an OPC cannot be incorporated or converted into Section 8 company. Secondly, OPC cannot carry out any non-banking financial investment activity. Thirdly, OPC cannot invest in securities of any body corporate. And finally, it can never be converted into any other kind of company within a period of 2 years of its incorporation. However, this fourth disability has an exception. The OPC can be converted, in fact it has to be compulsorily converted into a private company or a public company in case its paid up capital becomes more than 50 lakh or its turnover exceeds rupees 2 crore. Friends, as we already know that every company has two main documents. First is the Memorandum of Association and second is the Articles of Association. So now let's look into the deeper picture of the memorandum. Memorandum is considered as a charter of the company. That is, it is in a way an order which is imposed on the company beyond which a company cannot perform any function. We can also say that memorandum defines constitution of a company, just like Constitution of India is the constitution for our country. In other words, memorandum defines the scope or powers of the company. What all is contained in the memorandum? So now let's see what are the contents of memorandum and how to change those contents. Contents of memorandum can be classified into 5 major clauses. First is the name clause, which mentions the name of the company. Second is the registered office clause, which states the state in which the registered office of company is situated. Third clause is the objects clause, which mentions the object for which a company has been incorporated and the matters which are necessary for their furtherance. Fourth clause is the liabilities clause, which mentions the liabilities of the members of company. And finally, the fifth clause is the capital clause, which mentions the authorized capital of the company. At the end of these 5 clauses, the memorandum is finally signed by its subscribers. Let's begin with the name clause. This clause mentions the name of the company. However, the name must be followed by certain suffixes. In case of one person company, its name must be followed by the words one person company, which must be written below the name. In case of private company, its name must be followed by the words private limited. In case of public company, its name must be followed by the word limited. However, if there is a Section 8 company, which may be either a private or a public company, it need not add limited or private limited words after its name. However, the name of Section 8 company shall include the words like foundation, forum, association, chambers, etc. Next, we shall understand how to apply for the name of company. For this, it must be remembered that the name shall not be such that it is identical or too nearly resembling the name of an existing company. Second, its use is an offense under any law. Third, its use is undesirable in central government's opinion. It shall also not contain any word or expression which gives impression that the company is connected with central government, state government, local authority, etc. Neither it should contain any word or expression which is prescribed by the central government. However, such a word or expression may be possible with the central government's prior approval. Further, to use the word bank in the name, a company must obtain a no objection certificate from the Reserve Bank of India. Similarly, to use the word exchange in its name, no objection certificate shall be obtained from the SEBI. Let's now see the procedure to be followed for reservation of name. A person who wants the name of a company to be reserved shall file a prescribed form with the registrar together with the prescribed fees. After being satisfied, the name shall be reserved by ROC for a period of 60 days. But if in the form any wrong or incorrect information has been furnished and such mistake has been found before incorporation of the company, then the ROC will cancel the name and further it will impose a penalty up to Rs 1 lakh. If such mistake has been found after incorporation of company, then ROC may direct either to change the name within 3 months by passing an ordinary resolution, or ROC may even order for striking of the company's name from the register. It may also make petition to the court for winding up of the company. Once a company has been registered with a particular name, can its name be changed later on? Answer is yes. This can be done by following a particular procedure. To change the name, first of all, a special resolution shall be passed by the company. Second, a written approval by the central government shall be taken. But such a written approval need not be taken if the change is only from the word private limited to limited or from limited to private limited. Third condition for change of name is that there shall not be any default in filing of annual returns, financial statements or documents with ROC on the part of company. Number 2, there shall not be any default in the repayment of deposits, debentures or interests thereon. Finally, on fulfillment of above requirements, the new name shall be entered by the ROC in the register and the ROC shall issue a fresh certificate of incorporation to the company. Besides voluntarily changing the name may also be required to be rectified in certain cases. Where name is identical or too nearly resembling to the name of an existing company, in such a case, central government may direct the company to change its name within a period of 3 months by passing ordinary resolution. Second case is where the name is identical or too nearly resembling to a registered trademark. In such a situation, central government may again direct the company to change its name within a period of 6 months, bypassing ordinary resolution. In both these cases, after changing the name, the new name shall be filed with the ROC within a period of 15 days. Next to the name clause comes the Registered Office clause. Section 12 of the Act provides for labeling of the company in certain cases. First of all, outside every office or the place of business, two things must be mentioned. One is the name of the company and second is the address of its registered office. Number 2, on the seal of the company, if there is any seal, the name of the company must be mentioned. Thirdly, on every business letter, business head, letter papers, etc., the name, the address of the registered office, the SIN number, that is the corporate identity number, the telephone number, fax number, email, and website address must be mentioned. And finally, on the hundis, promissory notes, bills of exchanges, etc., the name of the company must be mentioned. Within a period of 15 days from the date of incorporation, a registered office must be established. The registered office shall be such that it is capable of receiving and acknowledging all the communications and notices. Furthermore, within a period of 30 days from the date of incorporation, the verification of the registered office shall be filed with the ROC. Next, we will see the process of change of registered office of the company. There can be 4 possibilities. Let us say that our registered office is situated right now at Jaipur, Rajasthan. First case can be when we want to shift our registered office from a place in Jaipur to another place in Jaipur. Second possibility can be when we want to shift from Jaipur to Udaipur. In the third scenario, if our registered office is situated at Maharashtra, which is divided for the purpose of administration into 2 ROCs, one being Pune ROC and another being Mumbai ROC. The third case is when we are going to shift from the jurisdiction of Pune ROC to the jurisdiction of Mumbai ROC, both within the same state, Maharashtra. And fourth situation can be when we want to shift from one state to another state, that is in this case from Maharashtra to Rajasthan. Let's see the procedure for case 1. When the registered office has to be shifted within the same city, town or village. In that case, a very simple formality has to be complied with, that is, passing of a board resolution. Case 2 is when the registered office has to be shifted from one city, town or village to another city, town or village. In such a case, a special resolution needs to be passed. Third possibility can be when the situation has to be changed from the jurisdiction of one ROC to the jurisdiction of another ROC, both lying within the same state. In such case, 2 things need to be done. First, a special resolution has to be passed. Secondly, regional director's confirmation has to be obtained. For this purpose, within 30 days of filing the application with regional director, his confirmation will be obtained. Within next 60 days, such confirmation of regional director shall be filed with the registrar of companies, and within the next 30 days, ROC shall certify such confirmation. Fourth possibility is that when the company has to shift its registered office from one state to another. In such a case, a special resolution has to be passed and central government's approval has to be taken. As far as central government's approval is concerned, central government would dispose of the application within a period of 60 days from the date of application, and within a period of next 30 days, the order of government shall be filed with both the registrars, and the new registrar would give fresh certificate of incorporation. But it is to be noted, friends, that central government would give approval only after being satisfied that either the consent of creditors, debenture holders, etc. has been taken by the company, or the company has made suitable provisions for discharge of debts of such creditors, or the company has secured to discharge such debts. After the name clause and the registered office clause comes the third important clause, that is the objects clause. This clause states two things. First, all those objects for which a company is incorporated, and second, all the matters which are necessary for furtherance of such objects. Companies Act always prefers that the name must be representative of the activities of the company. That is why it says that if there is any change in the activities of a company and such a change is not reflected in its name, then the company shall definitely change its name within a period of 6 months. Just as the name clause and the registered office clause can be altered, the object clause can also be altered. The procedure for that is very simple. It can be done by passing just a special resolution in the general meeting of the company. But if a company wants to change its objects for which it had raised money from the public while the money is still unutilized, in such a case, to change the object, it has to comply with stricter provisions. Number 1, a special resolution has to be passed by postal ballot. Number 2, such a special resolution shall be published in a newspaper, and it shall also be published in the website of the company if there is any. And third, exit opportunity must be given to the dissenting shareholders, that is, those shareholders who did not give their consent on such a change. Such exit opportunity has to be given by the promoters and the shareholders who are having control over the company. Next, we shall move on to the next clause, which is the liabilities clause. What is mentioned in the liabilities clause? It mentions whether the liability of the members of company is limited or it is unlimited. Not just this. Further, in case of companies which are limited by shares, the liabilities clause of memorandum also states that the liability of members is limited to unpaid amount of shares. But if the company is a guarantee company, then the liabilities clause states the amount which the members undertake to contribute in the event of winding up of the company. Such amount would be contributed by the members to the assets of the company or to the costs, expenses, etc. of winding up. Capital clause mentions two things. First, the amount of capital with which the company is to be registered, which is also called the authorized capital. Secondly, it mentions the divisions of such capital into the number of shares and the face value of each share. For example, capital clause would mention the authorized capital to be rupees 100 crore, which is divided into 1 crore shares of rupees 100 each. Friends, after having done the memorandum and articles, let's now move on to the next topic, that is various doctrines. First of them is the doctrine of ultra vires. What is meant by the word ultra vires? The word ultra means beyond, and the word Vires means powers. Powers means anything which a company can do expressly or impliedly. As per the famous case named Ashbury Railway Company Limited versus Ritchie, any act which is beyond the powers of a company, that is ultra vires, is wholly void. Number 2, it is never binding on the company. Company cannot sue for such contract and neither can it be sued for such contract. Further, ultra vires acts can never be ratified by the company. However, if a company has obtained ultra vires money and if it has expended whole of such money, then the injunction can be filed by the lenders. But if the money has not been expended by the company, then the lender will become the debtor of the company. Next is the doctrine of constructive notice, which is a very important doctrine. It says that every person who deals with the company is deemed to have knowledge of its contents. He does not only have the knowledge, but he have understood it and read it in the proper manner. And if the outsider does any ultra vires act without the knowledge, then he has to do it at his own peril. We can say that this doctrine is totally against the outsiders and it is in favor of the company. Doctrine of indoor management is an exception to the last doctrine, that is, it is the exception of the doctrine of constructive notice. This doctrine was laid down in the famous case Royal British Bank versus Turkand. That is why this doctrine is also known as Turkand's rule. It says that no doubt the outsiders are deemed to have knowledge of the memorandum and articles, but outsiders are never bound to have notice of the internal affairs of the company. This way we can see that this doctrine operates wholly against the company and it is in favor of the outsider. However, there are certain exceptions to this doctrine as well. Where a person dealing with the company has notice of the irregularity, that is the internal irregularity, then he can never take the support of this doctrine. Number 2, where the transaction is unusual and the person is found to be negligent, then also the person cannot take support of this doctrine. Thirdly, where the instrument is a forgery, the indoor management doctrine can never operate because forgery is a nullity and forgery makes an instrument void. Friends, there are many documents in the company law which have to be filed either by the company or have to be filed to the company. How such documents need to be served is specifically mentioned in the Companies Act. So now we are going to look at the modes in which documents can be served. As far as the documents which are to be served to the company or to the officers of the company, the modes of service can be either through the registered post or through the courier service or through speed post or by leaving the document at registered office or through electronic or any other mode. If any document is served by the company to the registrar or to the members, then the modes of services available with the company are, besides these 5 modes, there is an additional mode, that is the ordinary post. If the document served through ordinary post is a notice of meeting, then it is deemed that such a notice is served after the period of 48 hours. But in any other case, it is deemed that the document is served in the ordinary course of time. Friends, now let us review the whole lesson, that is Unit 1 Preliminary. First of all, we took a note about the introduction of company. Secondly, we took a note of the features of the company. After the features of the company, we came to know about the concept of corporate veil. What is the meaning of corporate veil? What is the meaning of lifting of corporate veil? And what are the cases in which corporate veil can be lifted? After that, we came across various kinds of companies. After learning about various kinds of companies, we came to know how to convert a company from one form to another, particularly how to convert a private company into public and back. Next, we came to know what are the cases in which companies have to be registered and what are the cases in which this Section 464 was not applicable. Next, what was the meaning of promoters and how the process of promotion was to be initiated. In the next part of this preliminary portion, we came across the whole process of registration or incorporation of company. Next, we saw how preliminary contracts are executed, what are they, and is the company bound by such contracts. Next, we came across in detail the Memorandum of Association. Next, we learned 3 doctrines. One was the Doctrine of Vires, Doctrine of Constructive Notice, and thereafter the Doctrine of Indoor Management. Finally, we saw last topic, which was the service of documents. Service of documents by the company as well as service of documents to the company. Thank you, friends.